Good afternoon, ladies and gentlemen. On behalf of the European Judicial Training Network, EJTN, it is our pleasure to welcome you at EJTN's webinar, the EPPO, Investigations and Prosecutions to Fight Crimes Against the Financial Interests of the EU. Following the EJTN goal of awareness raising on the EPPO, this webinar is aimed at providing a better understanding of the creation and setting up of the European Public Prosecutor's Office, EPPO, a unique body called to play a key role in the EU criminal justice panorama in the years to come and created to investigate, prosecute, and bring to judgment offences against the Union's financial interests. My name is Petra Wagner, Senior Prosecutor at the Office of the Prosecutor General in Munich, and I will be your moderator for this episode. Today, our presenter is Joachim Ettenhofer, Chief Prosecutor at the Office of the Prosecutor General in Munich, an EJTN contact point for Bavaria, Germany. The objectives of the webinar are to raise awareness and provide a better understanding of EPPO structure and organization, task of the EPPO, judicial review, cooperation with national authorities, member states not participating at the EPPO, relations with Eurojust, Olaf, and Europol. You can interact with the webinar through typing your questions and observations. The chat box, many of you have already found it, I see. The chat box that you see in the bottom for technical questions or observations. Everybody will see all comments written in the box. This box can be used also for asking questions relating to the contents of the webinar. The questions will be collected and we will try to answer as many of the questions as possible during the presentation and at the end of the presentation. Now I'm starting with a question. I kindly ask you to type your response into the chat box, which you will find on the screen at the bottom right-hand side. You would like to ask all of today's participants, who have not already done it, which country they are joining us from. I already see people from Latvia, hello, Finland, hello Jonna, Germany, Hungary, hello, from Spain, from Italy, from the Czech Republic, Germany is quite, hello from Lithuania. Well, that's great. And I see that it's a real pan-European audience. Thank you very much for your answers. So finally, when we close our webinar, you will see a URL link from our screens to our online survey about this webinar. Please do complete the survey, as the received feedback will help improve and shape EJTN's future webinar program. Remember, at the end of the session, you will receive a link which will allow you to re-access to the presentation held in the week. You will be able to join just those individual webinar broadcasts you wish. A few words about EJTN. EJTN brings together judicial training institutions from all European Union and supports the interests of over 120,000 European judges, prosecutors, and judicial trainers across the EU. The aim of EJTN is to help foster a European area of justice and to promote mutual recognition and trust between judicial systems and practitioners. Now, it is my great pleasure to turn this webinar over to our presenter, Mr. Joachim Ettenhofer.
Thank you, Petra, for introducing the webinar. Hello, everybody throughout Europe. I will give you a short or very, well, not exactly short, but a rough presentation, a rough overview of the EPPO, the plans for the future. The legal basis for the EPPO is the Council Regulation of October 2017, and it's implementing an enhanced cooperation on the establishment of the European Public Prosecutor's Office. This whole legal action is based on Article 86 of the Treaty on the Functioning of the European Union. The first proposal for this was on 17 July 2013 published, and it has been a long way to this point. My first international conference I attended back in 2002 in Bucharest was on the EPPO, and then it simply disappeared and suddenly it popped up again a few years later. And now we have indeed the legislation, the legal basis for the EPPO to take its place in the international environment. The EPPO will be responsible for investigating, prosecuting, and bringing to judgment of offences against the Union financial interests. That's the wording in Article 86, paragraph 2, and Article 4 of the EPPO regulation. The reasons for establishing the EPPO was in principle that the statistics were not that good than expected. You know, at the moment and in the past, Olaf was responsible for investigating offences against the financial interests of the EU. So Olaf conducted some administrative investigations, and at the end of the investigations, when they thought, well, there is enough evidence, they reported these cases to the member state in question. And there was a huge difference in the follow-up to these reports. To say, well, how many judgments have there been, and also how many indictments, how many terminations of the proceedings because of lack of evidence and all those things. And the statistics were quite different in the different countries. And therefore, the opinion was that it is necessary to create a body who is responsible for fighting these offences, to have a more effective weapon against offences against the financial interests of the EU. The structure of the EPPO. Well, it's a union body. It's a single office with a decentralized structure. The seat is in Luxembourg. We have the central level in Luxembourg and the decentralized level in the member states of the EU. It's like a body. The head is in Luxembourg with the brain, and arms and legs are inside the member states. At the central level, we have the European Chief Prosecutor, we have Deputy European Chief Prosecutors, European Prosecutors, and the Administrative Director. The Administrative Director is, though not involved in the investigations, the main actor in respect of administration and finances, and therefore extremely important. At the decentralized level, we have the European delegated prosecutors, so in the member states. The task of the European Chief Prosecutor, he shall organize the work of the EPPO and direct the office. He represents the EPPO vis-à-vis the institutions of the Union, the member states, and third parties. He will have 2 deputy European Chief Prosecutors to support him in these tasks. The European Chief Prosecutor is appointed for 7 years. That's not renewable by the European Parliament and the Council. And at the moment, we are in the phase that the first European chief prosecutor is to be found. And well, we have no decision yet. There have been 3 candidates shortlisted by the so-called an evaluation selection panel. One from Germany, who has been third and is out of the race at the moment, and then we have Jean-François Bonner from France and Ms. Kövesi from Romania, and these two are, well, one of these two will become the first European chief prosecutor. The Parliament favors Ms. Kövesi, the Council Mr. Bonner, and so a decision has to be made, and it has to be made soon. We then have the College of the European Chief Prosecutor and the European Prosecutors. There will be 1 European prosecutor per member state. This college will decide on the strategic matters, general issues, and internal rules of procedure. The last is extremely important in the first phase of the EPPO. That is, when the college is ready, it will be 1 year before the EPPO becomes operative, because you need some time to organize things, and especially also give yourself rules of procedure. And the important thing is that the first rules of procedure are really, really important, because mistakes you make at that point will perpetuate in the future. So you have to be very clear, precise, and very careful. Beside the college, we have the permanent chambers. That's the deciding body concerning specific cases. 3 members, 3 European prosecutors. They direct and monitor investigation and prosecution conducted by the European delegated prosecutors. They decide on bringing a case to court, dismissing a case, applying a simplified prosecution procedure, referring cases to national authorities, and all those things. So that's the deciding body within the European Public Prosecutor's Office. And it will consist on 3 European prosecutors, but not the European prosecutor responsible for his country is not within this chamber. So if it's a case of Germany, then the German European prosecutor won't be in this chamber. The chamber may give instructions to the handling European delegated prosecutor. They may delegate their decision-making powers, indicting, dismissing cases, to the European prosecutor in less serious and complex cases with damage less than 100,000 euros. The European prosecutor of the country involved. Then we have the European prosecutors. The European prosecutors supervise the investigations and prosecutions of the European delegated prosecutor of their member states. So the German one supervises the German delegated prosecutors, the French one, the French delegated prosecutors, and so on. They have the task to present summaries of the supervised cases and proposals for decisions to the permanent chamber. So the European delegated prosecutor files a report. The report is sent to the European prosecutor. The European prosecutor will evaluate this report, the case, and then present it to the chamber. The European prosecutor will participate in the deliberations of the permanent chamber with a right to vote. So in the end, it's 4 people to decide. And also the European prosecutor may give instructions to the European delegated prosecutor. The appointment of the European prosecutors is a little bit different Then the appointment of the European Chief Prosecutor. The European Chief Prosecutor, there was a vacancy note in December, so no, a little bit earlier in November. So everybody with the professional background could apply. It's different with these European prosecutors. The member state nominates 3 candidates for the position. At the moment, the deadline for the member states this time is 31st of March this year. So the candidates of the member states should be nominated by that. The Council appoints one of these 3 candidates for a non-renewable term of 6 years. This 6-year term may be extended for a maximum of 3 years. So it's 9 years maximum. And the reason for the 9 years is because if it's 10 years or more, there are some pension rights, EU pension rights, and obviously the EU don't want to have EPs, European prosecutors, getting pensions from the EU. And the first term for a third of the candidates will be shortened to 3 years. Why? Because the goal is that not all of the European prosecutors change at once. So it's 1/3 of the 3 years, 1/3 of the 6 years, 1/3 of the 9 years. So you have a permanent rotation. 2/3 of the European prosecutors stay there, and 1/3 is changed. So you have always some level of experience there and some new blood, so to say. The European delegated prosecutors in the member states, they are the ones who handle the cases in their member state, so investigate and prosecute in the same way like national prosecutors. They have a so-called double head, so they are on the one hand European delegated prosecutors, on the other hand but national prosecutors. They have all the rights of a national prosecutor, and they may also deal with national cases when they have enough time for that, besides their job as European delegated prosecutor. There has to be a minimum of 2 European delegated prosecutors per member state. The number of the European delegated prosecutor hasn't been decided yet. There are some ideas of the Commission, European Commission, for the number based on the statistics of Olaf regarding the number of cases Olaf sent to the respective member state. For example, for Germany, the initial idea was that there will be 4 European delegated prosecutors, but in the end, it will have to be negotiated between the European Chief Prosecutor and the member state somewhere in 2020. So we will have to see how many European delegated prosecutors there will be in each member state. Of course, small member states have less European delegated prosecutors than large European member states of the EU, and also it depends on the potential cases. The European delegated prosecutors are nominated by the member state and appointed by the college for 5 years, and this 5-year term can be renewed and renewed and renewed. So in theory it's possible to serve 30 years as European delegated prosecutor. I doubt whether this will happen in practice, but in theory it's possible. And there is also no regulation on some shortening of the period, or so that in theory all the European delegated prosecutors could be changed after 5 years. I don't expect that, but in theory it would be possible. Competence of the European Public Prosecutor's Office. We have the material competence. They are competent in respect of offences affecting the financial interests of the Union covered by the so-called PIF directive. So that's fraud affecting Union's financial interests. That's money laundering, corruption, misappropriation, and very important, and it was much disputed during the negotiations on the PIF directive, VAT fraud when the damage at least is 10 million euros. And you know, in big VAT fraud cases, this damage is not very high indeed. So the EPPO will have to deal with quite some VAT fraud cases in the future. The EPPO is also competent for offences inextricably linked to PIF offences, so maybe some forgery of documents that's quite often involved with fraud. So the EPPO would also deal with the forgery of documents. While the EPPO regulation is a regulation, so it's enforced when it's enforced, the PIF directive has to be implemented by the member states. And the problem is that, of course, the PIF directive might be implemented in the different member states in a slightly different way, so that the legal provisions don't have totally the same content. So there might be some differences, and that can cause problems in the practical work then. We will have to see. The EPPO is competent for offences committed after entry into force of the EPPO regulation that was in November 2017. So what's before November 2017 falls not into the competence of the EPPO. Territorial and personal competence. The offences have to be committed in whole or part within a member state or by a national of a member state. And it's a shared competence. So also the member states are competent for these offences. So there is no exclusive competence, but a shared competence. So in principle, as well as the EPPO, the member states authorities could prosecute and investigate the offences. Now to the investigations, the initiation of the investigations. Institutions, bodies, agencies of the Union, authorities of the member state, they all have to report offences falling into the competence of the EPPO to the EPPO. So because in the end you have to get all those cases. So and therefore there is some duty of especially union bodies to report things. Also information by judicial law enforcement authorities of the member state which investigates offences falling into the EPPO competence. They can also report or have to report. Then, of course, like in every prosecutional area or law enforcement area, the information can come from various sources, from any other source. And yet it can come from newspapers. So it's like there is no huge difference to Germany, for example. Vice versa, the EPPO has to inform the national authorities of criminal offences outside of the EPPO's competence. For example, if the EPPO investigates some VAT fraud and by the way they discover that there was some murder, of course they have no competence to deal with that, and then they have to inform the national authorities. The EPPO has then, after getting the report, initiates investigations or uses right of evocation unless the damage is less than 10,000 euros or the maximum sanction for the linked offense is equal or higher unless the linked offense has been instrumental to commit the PIF offenses. So, for example, if it's some murder case in connection with PIF fraud, then it may be the member state to deal with these cases. If it's forgery of documents, then it's the EPPO. Also, if the damage to other parties is higher than to the union's financial interests, then it's also case for the national authorities, unless it's VAT fraud, because in VAT fraud, normally the damage for the national budget is higher than for the union budget. So then the EPPO would never have to deal with VAT fraud, and that's not the sense of the PIF directive. So therefore, in VAT fraud cases, it doesn't matter how much the damage ratio member state EU is, but it's always then the EPPO. If there is a disagreement between the EPPO and the national authorities on the competence, this has to be decided on the national level by those authorities which decide on the national level on that. So that can be totally different who can decide this. In some cases it might be the court, in some cases it might be a higher prosecutional authority. Can be different from member state to member state. If there are reasonable grounds for offenses within the EPPO's competence, the investigations have to be initiated by the European delegated prosecutor itself or on instruction by the permanent chamber. Well, in the end, it depends. If the European delegated prosecutor gets a report by somebody that there is some criminal offense, then he can initiate the investigations by himself at once. If there is some Olaf report to the EPPO headquarters in Luxembourg, then, for example, there will be some information of the delegated prosecutor by the permanent chamber and then he will initiate the investigations. Competence regarding territory. The case is handled by the European delegated prosecutor from that member state where the focus of the criminal activity is, or the bulk of offenses has been committed. That's quite normal. Why should the investigations take place in some big case in a country where one act has taken place and not in the country where, well, 27 of the acts took place? It's like in national cases. Of course, it's a rule. So if there is a rule, you always have deviations from this rule, if there is reason for that. For example, residence of suspect, nationality, place where the damage occurred can be such criteria. And there is the possibility to reallocate, merge, split cases if there is jurisdiction in more than one member state. You start investigating things in Bulgaria, then you see, well, it was in Bulgaria, but it was more in Romania and some connections to Belgium, and then you in the end have to decide whether the case should stay with the Bulgarian delegated prosecutor or moved on to some other place. Right of evocation. Evocation means the case is dealt with by a member state and the European Public Prosecutor's Office takes it over on its decision. The right of evocation. Receiving information about national investigations of offenses falling into the EPPO competence. That's clear. The decision of the EPPO, so the European delegated prosecutor of the concerned member state, then will be whether or not to use its competence. If the damage is less than 100,000 euros and no need to prosecute the case at union level, there is the possibility to decide not to evoke the case. So it's some discretion in it. It depends on the specific case. And in the future, depending on the workload of the EPPO, it might also depend on simply the workload. If they're flooded with cases, then they will tend to leave the cases at the national level. If they have nothing to do, well, they might have a tendency to evoke cases. Within the legal framework, of course. The other way around, referral of proceedings to national authorities. If investigations of the EPPO reveals that the offense doesn't fall into the competence of the EPPO, the permanent chamber shall decide on referring the case to the national authorities. That's obvious. If you're not competent and there is a criminal offense, you have to present it to the authority who is competent to investigate and prosecute this offense. If the damage is less than 100,000 euro and no need to prosecute the case at union level, possibility to refer the case to the national authorities. It's quite the same like on the last slide with the evocation. You can decide not to evocate the case, but you also can decide to refer a case to the national authorities if it's already at your office. Conducting the investigation. The investigations are governed by the national law. The case is handled by the European delegated prosecutor. So it's handled like a national case. All those investigation measures you can use in your law, you can use as a European delegated prosecutor. Of course, the European delegated prosecutor doesn't do all the investigations by himself. He can use the law enforcement authorities of his member state to do that. Like normal prosecutors who can use police to investigate, to carry out searches and seizures, whatever. But the European delegated prosecutor is not allowed to use his fellow prosecutors. So it's not possible to say, oh, fellow prosecutor of my member state, well, I have too much work to do, please do help me with my case. That's not possible. It's the law enforcement authorities, but not prosecutors of the member state, other prosecutors of the member state. Cases can be reallocated from one European delegated prosecutor to another if the handling delegated prosecutor cannot perform the investigation or fails to follow instructions of the permanent chamber or the European prosecutor. The European Public Prosecutor's Office as such is independent, completely independent from other authorities. But there is no independence within the European Public Prosecutor's Office. So there can be instructions to handle cases, how to handle cases from the upper level to the lower level. So from Luxembourg to the delegated prosecutors. That creates problems with some participating member states, but because in some penal procedural codes or the constitution, there is an independence of prosecutors written in. So that's a problem. If in national cases there would be an independence, but it's not in those EPPO cases. In exceptional cases, the supervising European prosecutor may conduct the investigations personally. So the Dutch European prosecutor may conduct Dutch investigations. And therefore, it's necessary that the European prosecutor has to have the prosecutorial powers of a European delegated prosecutor of his member state. So in the end, he has to be a prosecutor of his member state also. Because the difference is, if you're a European prosecutor, you're no longer formally, for this period of time, a prosecutor of your member state. You're no member of your judiciary. You're EU official. You will sign a contract with the EU. So you have to get powers, prosecutorial powers, from your member state. Even if when your contract is over, you will go back to your member state and be prosecutor without any further things. But for the time being in Luxembourg, you need some extra powers. The investigation measures of national law of the member state of the delegated prosecutor are the ones to be used. Use of national law enforcement authorities, I've already touched upon this. And there is some kind of catalog which investigation measures the member states should at least have in place. So search and seizure, production of computer data, freezing of proceeds of crime, if the maximum penalty for the offense is at least 4 years. The maximum penalty, not the minimum penalty, of course. Well, the EPPO has been created for cross-border cases because protection of the financial interests of the EU, that's, I assume, in nearly all cases cross-border at some point. Cross-border investigations, they are not MLA within the participating member states. So it's not necessary that the European delegated prosecutor from Luxembourg or Belgium sends an MLA request to his colleague, the other European delegated prosecutor in Spain. He just sends a letter and asks for this and that measure carried out. Well, in the end, it's also a kind of request, but it's not mutual legal assistance. It's just within one authority. One colleague writes to another colleague. If there is the necessity of judicial authorization, for example, for search and seizure or telecommunication surveillance or whatever, it has to be obtained by the assisting European delegated prosecutor. So the relevant law is the law of the country where the investigation should take place. If it's not necessary under that law, but under the law of the handling delegated prosecutor, then the authorization has to be asked for in this country. Then it's the next step is the enforcement of the measures takes place under the law of the assisting European delegated prosecutor. It's quite clear. It's like in MLA also. But if there are special formalities and procedures of the law of the handling European delegated prosecutor, that should be complied with. It's also nothing new for all those who are dealing with MLA, because also now for example, in the European frameworks, there is this clause that the execution should comply with special provisions asked for. Of course, we also have arrests, and then we have but that's the European arrest warrant can and has to be used in cases of cross-border arrests. It's not just arresting and handing over without any procedure. Termination of investigations. When the European delegated prosecutor completes the investigations. He submits a report, that's a summary of the case and a draft decision, to the supervising European prosecutor. This European prosecutor evaluates the case and forwards the report to the permanent chamber, and then there will be a decision of the permanent chamber. Of course, there are the three main possibilities. That's bringing a case to court, dismissal, or simplified prosecution procedures. Bringing the case to court. In the member state of the handling European delegated prosecutor. Evidence gathered should not be denied on the ground that it was gathered in another member state. Of course, that's the logical consequence of cross-border investigations, especially within the range of the European Public Prosecutor's Office, where one European delegated prosecutor asks his colleagues in the other country for getting the evidence. But of course, the court can assess the evidence freely. That's nothing new. That's a typical thing in all court procedures. Dismissal of the case is clear. If there is a lack of evidence, then the case will be dismissed. And if there is a simplified prosecution procedure in place in the country where the delegated prosecutor conducts investigations, then of course those simplified prosecution procedures can be used. Rights of suspects. Fair trial and rights of defense is enshrined in the Charter, right to interpretation, information, access to a lawyer, right to remain silent, presumption of innocence, legal aid. That's all things which are quite obvious, and they also are enshrined in the so-called ABC directives of the EU. So that's nothing unusual, but it's just the normal rights of suspects they should have in every case in every member state. Judicial review. There have been a lot of discussions on judicial reviews during the negotiations. The end of the game was the review will be carried out by the competent national courts. It's national in principle. It's everything is the investigating prosecution service is international. It's the European Public Prosecutor, but the proceedings are national, are exactly the national ones. The same courts, the same codes, criminal code, criminal procedure code. It's all the same. The only difference is that it's not the investigations by the local authority, but by some kind of supranational authority. Also, the Court of Justice of the European Union comes into the picture if it's upon the interpretation of union law. It's like in the EAW proceedings, where a national court can ask for some interpretation of union law in some cases. Also nothing very new. Relation with other actors. Of course, there will and have to be relations with other actors. That's Olaf, Europol, Eurojust, third countries, and non-participating member states, because the European Public Prosecutor's Office will consist of 22 participating member states, so there are some which are not in, and therefore there have to be some relations. It will be, of course, interesting how those things will work out, because, well, MLA, there will have to be MLA requests from participating member states, delegated prosecutors placed there with other countries. because not all the cases will play within the framework of the 22 member states participating, but also in other member states and also in third countries. And so the question is how that will be dealt with. If there is an article in the regulation, of course, on that. So in principle, the European Prosecutor's Office, Public Prosecutor's Office, should be notified by the member states as competent authority for sending MLA requests to other countries. Whether the other countries will accept that has to be seen, and whether the member states will all do this notification, we also will have to see. Or the European delegated prosecutor should use his national competence to draft MLA requests in third countries. So it will be very interesting how this will work out in practice, whether there will be any difficulties. It has to be seen. Well, now we come to the participating member states. It's easier the other way around, non-participating member states. Denmark, Hungary, Ireland, Poland, Sweden, and the UK. Well, the UK is still a member state. We don't know for how long, at least a few days. Maybe next week I have to delete this from the presentation. But for the time being, that's it. So it's quite a huge area, and there are not too many not participating. But maybe some or the other will join later. The time frame. Appointment of the European Chief Prosecutor should be done in April 2019. One reason for that is that in May we will have the elections, and so that might hinder things if it's not done before. So we should have a decision on the person of the first European Chief Prosecutor within very short notice. November 2019, the European prosecutors shall be appointed. In September 2020, the European delegated prosecutors, and in November 2020, the EPPO should be operational. I have seen some time frames in the past, and it was astonishing because the times moved on. So in the first drafts I saw of this time frame, the European Chief Prosecutor had to be appointed much earlier. Also the European Prosecutors, it was at some point in May 2019 and so on. The only thing which stayed the same is November 2020 EPPO operational. In the regulation, there is a provision that the EPPO should be operational the earliest point 3 years after coming into force of the regulation. So that's November 2020, and yeah, the EU, the Commission, sticked to that point, and yeah, we will have to see. Because in the end, the college has to decide, or will state the date of becoming operational. Problems. There will be some, I can assure you. Creation of the case management system, IT infrastructure. IT is always crucial. And you have IT infrastructure in the member states. The tendency is to have an electronic file at some point in every member state, in every criminal proceeding. That's the future, but we haven't it now. At least not in most member states. But the IT infrastructure within the EPPO should be that way that they can communicate easily. So they need more or less the same IT system. And to create that is a huge task. And there is not too much time. And the next problem is that For example, in Germany, there is no decision on the structure of the EPPO within Germany yet. We don't know how it will look like, where the centers will be, how it will be structured. Will be there one center of EPPO in Germany, more than one, how many persons, where, and you need this information to build up the IT structure. The next thing is adaptation of national law. I've mentioned the problem with the independence of prosecutors. So, countries with those constitutional provisions, they might have to change their constitution before it's possible to really start working with the EPPO. Other countries have different problems. In Germany, it's more the law on public officials. Well, we have 16 federal states, and so we have 16 different laws on public officials and one for a federal law on public officials, so 17. Those things have to be streamlined with the EPPO regulation. Funny. And this all has to be done soon. And the problem might be that even if 21 countries are ready in November 2020, what will happen if one member state won't be happy, won't be ready? So it's quite tricky. Possible future developments. In the Treaty on the Functioning of the European Union, there is a possibility foreseen to extend the competence regarding organized cross-border crime and terrorism. And the problem is that the politicians already think about extending the competence of the EPPO to terrorism. Not that, of course, in some years. But even to think about that now is a little bit, well, not very sensible, so to say it this way. Because before you think about enhancing competences, you should see whether the EPPO fulfills its expectations. It can be a success story, and it can be the other way around. So I'm quite skeptical on that. I simply would wait to think about enhancing the competences. Wait and see. First a few years, and then what's good, what not. Evaluate those EPPO, the regulation, because the regulation is drafted for dealing with PIF offenses, protecting financial interests of the EU, and not terrorism. That's a totally different area. And yeah, well, we have to see. Politics are not always sensible, unfortunately. So we already have reached the final slide, and that's this one.
Thank you very much for the very interesting presentation, Joachim. Thank you so much. We will now move to the questions and answers point of today's program. If you, participants, have any questions you would like to ask our presenter, you might type in your questions now. I see there are many people typing already. I saw during the webinar that Jonas had a question, I think, and Marie. Joachim, you very well explained already all kind of aspects, but maybe there are some. Okay.
Well, I see the first question. That's where will the college be situated? It's in Luxembourg, like the whole office.
I think you have to wait until people have typed their questions. Thank you very much. Yes, of course. If you have questions, we will have to see what the future will bring, as Joachim said in his last slides, but so we have another question here. I put in the Dropbox. Will the EPPO also appear before national Supreme Courts?
They will appear for all. They will appear before all courts. They're handling the cases exclusively if they have an EPPO case. So therefore, they will appear also before Supreme Courts. And also therefore, some law might have to be changed within the countries.
I see the question whether the webinar can be reheard. It will be possible. Michael is already answering that. That will be possible, especially for those who were late in the beginning. Okay, see another question. I drop it here. Will it be compulsory for European delegated prosecutors to attend college?
Well, the European delegated prosecutors are in their member states, so it has to be seen how they have their rules of proceedings, but normally they won't attend meetings of the college.
Now I have a question from Marie concerning the training.
Well, in the end, of course they have to be trained, all those EPs and also the European delegated prosecutors, but it has to be seen how it will be done, because also that's a question which the EPPO itself and the college has to think about, and I'm sure that they will have some internal trainings on dealing with things, and well, some things are in the regulation, of course, and many problems will appear when it's operational then, and the practice will show what problems will arise. And so it's hard, but of course they have to be trained. And maybe it's something for the EJTN to deal with, training of European delegated prosecutors, or not only European delegated prosecutors, but also from national authorities, because the national authorities, judges, police, and all those have to be aware of the EPPO and the powers of the EPPO and how to deal with those.
Okay, thank you very much. We have a question from Soran. The question here, will Eurojust become obsolete and possibly a department in the European Public Prosecutor's Office, or is it about two differentiated bodies with separated competences and independent of each other, and what role Olaf will play in the relation to both agencies? Do you have a comment on that, Joachim?
Well, Eurojust won't become obsolete, because Eurojust, of course, covers also cases which fall in the competence of the EPPO, but they cover a lot of other things and other cases, and not all member states are participating in the EPPO, and so even in EPPO cases there might be the necessity to use Eurojust in coordinating things with non-participating member states. And also Olaf will play a role, because Olaf, of course, the same applies. Not all member states participate, but Olaf deals with all, well, deals with things concerning all member states, and internal investigations, for example, administrative investigations within the EU bodies will still
Yeah,
be there.
probably true. Gabriella is asking, how exactly will EPPO work with Olaf in terms of investigating offences? And will Olaf exercise most of its actual... Will Eurojust become obsolete? Okay, that's already mostly the same question. Yeah. So let's move to question 6. Yeah. How exactly will EPPO work with Olaf in terms of investigating offences? Will Olaf exercise most of its actual competences? And do you think Olaf, so it's mostly about Olaf, will be more present even in third countries' investigations?
Well, Olaf will have to deal with less cases within the EU member state, the participating member states. How exactly they will work together with the EPPO has to be seen. But as far as I know, at least some of the Olaf investigators should move or work for the EPPO. But, well, that's only some information. I have seen nothing concrete yet on that. But Olaf is not obsolete, and they have also in the future to gather information for criminal offenses.
Let's move to question number 7, Babek. The question is, do you know the time frame for the hearings for the European prosecutors before the selection panel?
Nothing definite. It should be in the summer, but the only time I know is end of March for the appointment of the 3 candidates per participating member state, and also when they have or should be appointed. But on the time frame, it also depends on the selection panel. But during the summer, if they should be appointed in November, it has to be during the
quite
summer,
some time frame.
or even earlier.
There are 2 questions from Spain. First, Jose. What do you think about the systems where the investigating judge is who directs the investigation? It could be an additional problem to adapt in the national law. It should be the national law with the EPPO.
Exactly, yeah, that's one of the problems. I have mentioned it explicitly when I talked about problems and the national law. But it's also a tricky question, because if there is an investigation judge, it doesn't fit exactly into the prosecutorial system of the EPPO. So the national law has to be streamlined with that. In what way ever? Yeah, I don't know. It's up to the member state to, well, change its law in the way that the EPPO fits in.
Yeah, still some way to go. Elsa, thank you for your question. It's about the double head, which you mentioned, Joachim. So you mentioned that European delegate prosecutors would have a double head. How could it be possible that they are less independent when acting as delegated EPPOs than as national prosecutors? Would that be a double standard for defendants? Isn't it more logical that, instead of changing national constitutions, the internal rules of procedure say that instructions from EPPO should stick to the national limits of the EDPs?
In my opinion, it's not a double standard for the defendants, because in the end, whether you're independent or not independent, you have to follow your law. So conduct investigations legally and all those things. And of course, it can be in national cases independent, in EPPO cases not independent, and, well, the decision has been made in the regulation. EDPs are not independent in the sense they might be in the national law. So the decision has been made, and now the member state participating has to follow.
Thank you very much for the answer. I see that Babek and Gabriela are still typing. Or maybe some other persons have questions. Sergio is past typing. A long question is waiting for us. So we have a question from Sergio. On what basis, further than the lack of evidence, will the college decide to dismiss a case? Should the national EPPO delegate give his consent? I copy it here. It's a question from Sergio. Yeah.
Well, in the end, I think it will be lack of evidence. Of course, they also can decide to dismiss a case on base of discretionary provisions in the member states, because the guilt is very minor or something like that. And if you mean the national EPPO delegate, if you mean the European prosecutor, he will have his vote during those deliberations of the chamber. So he will also can have his say, but the EDP the EDP makes some proposal to deal with the case, and well, he's the one who knows the case, who investigated the case. I assume that mostly the permanent chamber will follow his advice or his proposal. That would be the normal thing, I think. Of course, if the permanent chamber sees something different or thinks that there is some potential evidence not yet gathered, they might ask the delegated prosecutor to...
Thank you very much. Now I got a very interesting question, I think, from Babek. What happens if an instruction given to the European prosecutor by the Parliament chamber does not comply with national law? Should there be provisions in the internal rules of procedure for such problems? That's quite interesting.
Well, of course, the instructions mustn't be against the national law. It's obvious. And, well, therefore, we have the European prosecutors also taking part in the deliberations of the chamber. And the European prosecutor should point out that there is some problem with the national law, with the instructions. Because, well, I think it's in all countries the same. You can't give instructions which are obviously unlawful. So it should be shouldn't happen. It might happen, of course, but then also the European prosecutor should point its finger to the problem, and also the delegated prosecutor getting the instruction should point out that it's not complying with the national law, and then it has to be seen. And maybe there should be then some decision by the college, I don't know. It has, well, there has to be something inside the internal rules.
There's another question from Soran. Can you comment on judicial control of the EPPO's work and validity of evidence? Can we expect EPPO participating states to respect decisions of every national judicial authority, considering the fact that these countries have different standards in evidence validity doctrine?
Well, admissibility of evidence is a huge topic, which I think in the future the EU will deal with. Normally, the evidence has to be evaluated by the court in the member state where the case is brought to court. And the standards of admissibility of evidence, as it's in principle a national case then, has to be evaluated on that basis. And the same problems like now with transnational cases and cross-border investigations will take place. There will be no difference to that. So it will be the same, only difference is that the prosecution authority is a different one. It's not the national, but it's the international one. But the problems and all those things will be dealt with in the same way, like in purely national cases. And also the problem with admissibility of evidence, also the problems with different preconditions for specific measures of investigation, for example, telecommunication surveillance. They're quite different in different countries. So the problems will be the same like we have nowadays.
Thank you very much, Joachim, for the answer. I think that's quite a variety of questions already. So thank you very much, ladies and gentlemen. We have received the last questions, I would say now. Truly interesting insights and perspectives. Thank you very much. Thank you very much, Joachim Ettenhofer. We now close our EGTN webinar. We hope you have found this a stimulating and value-adding event. When leaving the webinar, please do not forget to complete the evaluation form, as your feedback will help shape EGTN's future webinar program. Thank you. From all of us at EGTN, we wish you a pleasant afternoon.